Good afternoon, everybody. This is September 9th, Thurston County Board of Health meeting coming to order at 3:47. First item on our agenda is the approval of the September 9th, 2025 Board of Health meeting agenda. Is there a motion to approve the agenda?
I'll move to approve the agenda. Second.
So approved by Lynn Nelson, seconded by Tanzania Zanzali Marshall. So all in favor?
Aye.
Any opposed?
Aye.
Great. So the September 9th, 2025 Board of Health agenda is approved. Next item on the agenda is the approval of the August 12th, 2025 Board of Health meeting minutes. Is there a motion to approve the minutes?
I'll move to approve the minutes. Second.
So that was moved by Lynn Nelson, seconded by Heidi Canedo. All in favor?
Aye.
All right, so the August 12th, 2025 Board of Health meeting minutes are approved. And the next order of business is to proclaim the month of September 2025 as National Preparedness Month. And I'd like to invite Alex Dingus and Kyle Busta to say a few words.
Good afternoon. As we begin the month of September, we recognize National Preparedness Month, a time to focus on our shared responsibility to prepare for disasters. Every year, FEMA, through its Ready campaign, determines the theme for National Preparedness Month. This year's theme is Preparedness Starts at Home. This year's theme underscores a profound truth. The foundation of community resilience lies in individual action. It reminds us that while disasters can be overwhelming, simple actions can make a big impact on our resilience when facing disaster. What actions can you take to prepare yourself? 1, know your risks. Every community has its own specific threats. This can include flooding, wildfires, earthquakes, power outages, public health emergencies, and others. Understanding potential dangers can help you tailor preparations to be most effective. 2, make a plan. Families should discuss and practice emergency plans. Discuss communication methods and meeting locations if separated. When making your plans, ensure you consider any unique needs of those that you care for, whether it be medical conditions, loved ones with disabilities, any pets, or any neighbors who might need help getting prepared. 3, build a kit. Having an emergency kit or go bag ready, or both for shelter in place and evacuation, is important. Ensure you have enough food, water, medicine, and other vital supplies to last at least 3 days. Include any important documents and create your kit to meet your family's needs. 4, get involved. Preparedness requires teamwork. Talk about preparedness with your neighbors, family, friends. Consider taking a CPR class. Medic One offers one for free. Or consider taking a community emergency response team class, which emergency management offers for free. Community level action strengthens our resilience as a county. We all have responsibilities for our families, pets, neighbors, and community. By taking steps now, you can be in control of both your safety and those you care about before, during, and after disaster. We hope that this September, you will take steps to improve your personal preparedness. Thank you.
Hey. And is there just one speaker today?
That's me.
Okay. Now the board will read the proclamation. And I don't know if either end is more prepared, but we'll start with Commissioner Klaus, if that's okay.
Definitely. In honor of National Preparedness Month, I was very prepared to read the proclamation. So
Excellent work.
start out Thurston County.
Model the way.
Thank you. National Preparedness Month, whereas the month of September is recognized as National Preparedness Month, a time dedicated to encouraging individuals, families, and communities to prepare for emergencies and disasters by taking proactive steps such as creating emergency plans, assembling disaster kits, and signing up for local emergency alerts. And
Whereas emergencies can occur at any time, often without warning, and may result from natural disasters such as earthquakes, floods, wildfires, and severe storms, as well as from human-caused incidents and health-related emergencies such as pandemics. And
Whereas preparing for emergencies can significantly reduce the loss of life and property, lessen disruption to daily life, and help our community recovery more quickly. And
Whereas preparation includes knowing the hazards that affect our area, plotting evacuation routes, knowing where to receive information from trusted sources, assembling an emergency kit, and developing a personalized emergency plan that keeps potential medical needs, pets, and vulnerable populations in mind. And
Whereas every community member is encouraged to register for TC Alert, which will notify community members of potential hazards within Thurston County. And
Whereas community resilience depends on partnerships between local government, businesses, nonprofits, and residents working together to strengthen preparedness and response capabilities. And
Whereas by working together and taking simple steps now, we can help ensure a safer, stronger, and more prepared Thurston County.
Now therefore, be it resolved, the Thurston County Board of Health hereby proclaims the month of September as National Preparedness Month in Thurston County and urge residents to enhance their resilience and readiness by preparing for disasters.
great. So everybody, we can join in the lobby for a photo. All right, everybody back. The next order of business is to proclaim the week of September 15th through 18th as Septic Smart Week. So I'd like to invite Stuart Whitford and Meg Morehouse to the table to say a few words.
Good afternoon, Stuart Whitford, Environmental Health Program Manager, supervise support programs for environmental health, one of which is Dr. Leslie King Foss supervises the on-site operations program. Focused on maintenance of septic systems. So in celebration of Septic Smart Week, I ask that you search tonight for the homeowner maintenance program on our Thurston County. And you actually will arrive there, which is good. This program has been around since around 2008, and we currently have 3,000 septic system owners involved in the maintenance. And so to provide you a snapshot of that program, we have Maggie Morehouse here, who's an environmental specialist to the operation and maintenance.
Welcome.
Thank you for having me. So I'm Maggie and I teach our homeowners class. I did have a PowerPoint, so I'm not sure if it's going to show up behind me. But so we have 2 classes a month from January to November. We don't have a class in December because of the holiday season. We did expand from the MRA, Henderson and Nisqually out to anybody in the county for whose system qualifies. If they want to inspect our system and talk about it, we're happy to teach them. The class is about 3.5 hours long. We give them all their septic handouts for that class. Then before they come to the class, they watch the DOH video that's on the state DOH webpage. We emphasize strongly safety. People can't hurt themselves working with septic, so I emphasize safety when they're doing this. I demonstrate how to do the inspections, talk to them about how to use their system, what common failures look like, and then how to actually make some of the repairs for those most common failures. And then the most important part, how to report those findings to us. Some of the class feedback that we get, people are really excited, but some of the feedback is that they learn how to value their septic system. They have reduced fear because now they understand how it works, what can go wrong, and how they have to actually fix a lot of those things that can go wrong. And that empowerment that they can take care of their own septic system. The next thing that we love is that they have excitement then to go home and put this into practice and to tell their neighbors about how to love and care for their septic system. If I can leave you guys with one advice, the most simple septic advice that I could give to anybody, which is do not flush anything down a drain if it has not gone through you, or if it's a little amount of toilet paper. Thank you.
Got it. All right, the board will now read the proclamation after that excellent advice. Are you okay going the other way?
Septic Smart Week, whereas proper septic system use and routine care help avoid costly septic system repairs and protect the investment that homeowners have in their septic systems. And
Whereas septic systems that are properly designed and maintained are vital to protecting public health are invaluable drinking water, lakes, rivers, streams, Puget Sound, and our shellfish industry, which produces almost 6 million pounds of shellfish each year. And
Whereas there are nearly 54,000 septic systems in Thurston County that treat and dispose of almost 12 million gallons of sewage per day. And
Whereas Thurston County's on-site system professionals, our environmental health division staff, and our community partners use their expertise in the design, installation, maintenance, and regulation of septic systems in our county. And
whereas the Environmental Protection Agency and the Governor of the State of Washington have declared September 15th through 19th, 2025 as Septic Smart Week to increase awareness and highlight the need for proper septic system maintenance across the state. And
Now, therefore, be it resolved, the Thurston County Board of Health hereby proclaims the week of September 15 to 19, 2025 as Septic Smart Week. Encourages Thurston County septic system owners to learn about their septic systems and for all residents of Thurston County to help us work toward ensuring our communities are safe and our environment is protected. Thank you guys so much for all you do and for coming today.
Dr. Harvey, we would like to do a photo because we have the whole.
Sure.
Oh.
Sorry, that wasn't on my agenda, but
Yeah,
would
thank-
love to do a photo. All right. And do we have anyone signed up for public comment? We'll check just to be sure, because that would be on our agenda if we have anyone. And I don't see anyone online.
no,
Okay.
we have not received any emails either.
Nope. Okay. All right, so we will move on. Here. So our next board item is to discuss about a possible November Board of Health meeting. So I don't know if you want to kind of talk a little bit about it, Dr. Freiheit.
sure, as I understand, we normally do not have a November Board of Health meeting because that was typically the time with the WASAC conference, so they conflicted. The past 2 years or the past 1 year, they have been a week later. However, the second Tuesday of November is also Veterans Day, so we can certainly entertain having a November meeting. There are some things that we could talk about during that time, but it would have to be the first Tuesday of November if that is something you wish to pursue.
I don't know with how much kind of work we've been trying to do and things we want to review, if you feel like we'll need that by the December meeting. I don't know. Any thoughts or opinions? If you-
That would be election day.
Yes.
Yeah.
November 4th.
Is there particular items?
Not anything in particular. It's just been mentioned a couple of times that there was enough to talk about. Should we have a November meeting? Didn't realize that was election day. So certainly there could be another date that is chosen, but yes.
And then I guess alternately, if there's a lot to cover, potentially if you'd be up for just a longer October or December too.
Mhm.
Is that okay? So it sounds like the preference would be not a November with all the days that it would fall on. No.
I'm open.
I'm open to it, but if the staff's saying that we can handle, I mean, if we've typically not had one and we can handle the items in October and December, I'm fine with that as well. I think it would have to be the 4th.
Okay.
Because the next week is WASAC and the next week is Thanksgiving week and then you're bumping up. So it would probably need to be the 4th if we're gonna do it.
Yeah,
We don't need it.
yeah, I'm flexible too. Like, yeah.
All right. And anyone on Zoom have any opinions or things you want to mention?
Nope, I'm okay with the board's recommendation. Can someone let me in, please?
Yeah, I'm also okay with it.
All right, so maybe we'll hold it as just a placeholder and then hopefully we won't need it. Sound good? Okey doke. Let's see, and next, health officer and director's report, on page 12 of the packet. If there are questions, feel free. There is a response to the question about the Pest and Vegetation Management Advisory Board's term limits, which looks like they don't have any because they're hard to recruit. And then if you have any questions for Dr. Freiheit about COVID vaccine or any of the other declarations that have been going on, she says she's willing to answer any questions. On Zoom, any questions? All right.
Can I ask a question?
Yes.
The term limits for PIVMAC, was that prompted because we have an opening?
The question came up last month because of the opening, that was,
Not by district, like they can be anywhere in the county?
I will have to get back to you on that.
Some of the noxious weeds, like some of them have like districts, but I can't remember this one. If it does and it's mine, let me know. I can try it.
All right. So now the board will go into executive session pursuant to RCW 42.30.140 and Thurston County Septic Code Article 1, Section 9 for 15 minutes to prepare for the appeal hearing, which is next on the agenda. All right, I'm going to start reading while you guys get settled, if that's okay. All right. Good afternoon. I'm Board Chair Dr. Beth Harvey. I'll be presiding over today's appeal. Here with me today are Vice Chair Commissioner Carolina Mejia on Zoom, Commissioners Ty Menser and Emily Klaus in person, and Commissioner Rachel Grant and Wayne Fournier on Zoom. County community members Perla Newton, Heidi Canedo, Lynn Nelson, Tanzania Zanzali Marshall, City of Olympia Representative Clark Gilman, and Squaxin Island Representative Ray Peters is on Zoom. Today's date is Tuesday, September 9th, 2025. Time is 4:31. And the Thurston County Board of Health is now on the record. On November 11th, 2024, Thurston County Environmental Health approved a septic system repair permit. Matthew and Madeline McCullough appealed this permit, and on May 2nd, 2025, the hearing officer issued a decision denying the appeal. Within that decision, the hearing officer directed Environmental Health to ensure prior to final on-site sewage inspection and record drawing acceptance that the site plan be revised to include the listed features and the distances from the on-site sewage to the listed features required to be shown on the site plan by Article 4, Section 8.1.3.10. On May 19, 2025, Matthew and Madeline McCullough appealed the hearing officer's decision to the Board of Health. In summary, the issues before the Board of Health today are whether the McCulloughs have standing, whether the Anderson on-site sewage permit required compliance with the Thurston County Critical Areas Ordinance. 3, whether the Anderson on-site sewage permit required compliance with the Shoreline Management Act and Shoreline Master Program. Number 4, whether the Anderson on-site sewage permit was an application for a repair or an application for expansion. Number 5, whether the Anderson well required compliance with Group B requirements. In quasi judicial appeals, the Board of Health is subject to the appearance of fairness doctrine codified in Chapter 42.36 RCW. Under this doctrine, board members are not authorized to have ex parte communications with the parties after an appeal has been filed with the board. However, if there have been ex parte communications since the appeal was filed, or communication or relationship with any of the parties that may appear to impact their impartiality, then the substance of that communication or relationship needs to be disclosed. In addition, each board member must be able to impartially judge this case on the facts contained in the record and the applicable law. At this time, I will ask each board member to make a declaration for the record. I will make mine first. Since the appeal was filed on May 19, 2025, I have not had any ex parte communications with any of the parties to this appeal. And I affirm that I can fairly and impartially judge this case on the facts in the record and applicable law. Let's go in room first and then we'll go Zoom second. So are you okay going first, Heidi?
Since the appeal was filed on May 19th, 2025, I have not had any ex parte communications with any of the parties to this appeal, and I affirm that I can fairly and impartially judge this case on the facts in the record and the applicable law.
Since the appeal was filed on May 19th, 2025, I have not had any ex parte communications with any of the parties to this appeal, and I affirm that I can fairly judge this case on the facts in the record and applicable law.
This is Clark Gilman. Since the appeal was filed on May 19th, 2025, I have not had any ex parte communications with any of the parties to this appeal, and I affirm that I can fairly and impartially judge this case on the facts in the record and applicable law.
Since the appeal was filed on May 19th, 2025, I have not had any ex parte communications with any of the parties in this appeal, and I affirm that I can fairly and impartially judge this case on the facts in the record and the applicable law.
This is Member Zanzali Marshall. Since the appeal was filed on May 19th, 2025, I have not had any ex parte communications with any of the parties to this appeal, and I affirm that I can fairly and impartially judge this case on the facts in the record and the applicable law.
Ty Menser, Thurston County Commissioner. Since the appeal was filed on May 19th, 2025, I have not had any ex parte communication with any parties to this appeal, and I affirm that I can fairly and impartially judge this case on the facts in the record and applicable law.
Emily Klaus, since the appeal was filed on May 19th, 2025, I have not had any ex parte communications with any of the parties to this appeal, and I affirm that I can fairly and impartially judge this case on the facts in the record and applicable law.
Great. Commissioner Mejia?
Thank you. Since the appeal was filed on May 19th, 2025, I, Carolina Mejia, have not had any ex parte communications with any of the parties to this appeal, and I affirm that I can fairly and impartially judge this case on the facts in the record and applicable law.
Commissioner Grant?
Since the appeal was filed on May 19, 2025, I have not had any ex parte communications with any of the parties to this appeal, and I affirm that I can fairly and impartially judge this case on the facts in the record and applicable law.
Commissioner Fournier?
I, Wayne Fournier. I'm sorry, I'm winging it here. I attest that I have not had any ex parte communications with any parties involved, and I am able to judge impartially based on the facts in the record, this case.
Okay, and Mr. Peters?
Yes, I, Ray Peters, attest that I have had no ex parte communication, and I can judge this case impartially as well.
So today's date is Tuesday, September 9th, 2025. The time is now 4:36. The Thurston County Board of Health is now on the record. So I think we are now at, any of the parties have any objections or challenges for the board member to decide the case? All right. So hearing no objections, we will proceed with oral arguments. The appellant and the department will each have an opportunity to present 15 minutes of oral argument. Oral argument may not present new information or evidence, but rather must be limited to the evidence on the record and specific issues raised in the appellant's appeal. If the board has any questions, then it will ask them during or after argument. And anybody have any questions before we start? Okay.
Usually you need to reserve that time if you like to.
And would you like me to give warning if it's getting close to 15?
Yes.
Okay, I'll give you like a 2-minute. Okay. All right. Let's see. The hearing is now open and the appellant has 15 minutes to present.
Good afternoon, board members. Can you all hear me okay? Yes. My name is Michael Ray. I'm with the firm Bricklin and Newman, and I represent the appellants, McCulloughs in this case. I don't expect to take 15 minutes, so I'll go ahead and I'd like to reserve whatever time I have at the end. Finish up. Before I get into the granular law and facts of this case, I'll start with a headline. I think that's relevant, or I think that's helpful. The headline of this case is that Thurston Health has been issuing permits to install replacement septic systems without the required review under the critical areas ordinance. So it's undisputed that the critical area ordinance requires critical area review for both new systems and replacement systems. But Thurston Health has adopted a policy where it only requires CPED or planning department review for new systems. So nothing in the code supports Thurston Health's policy of exempting repairs from critical area review. And Thurston Health doesn't cite any authority, and none came up in testimony that supports that policy. So because there's no dispute as to whether the critical areas ordinance review is required, Thurston Health focuses in its briefing on sort of two buckets that I'll start with. The first bucket is the hearing officer's authority to deny an OSS application based on non-compliance with the critical areas ordinance. And the second, I'm using critical areas ordinance, and I'm sort of wrapping in the shoreline master program, but I'm going to focus on critical areas ordinance just for simplicity. So that's the first bucket is authority. And the second bucket is sort of, I'll call it timing. And it's whether Thurston Health has to wait for the planning department to finish their review before they issue an installation permit to put a septic in the ground. So those are the two buckets that I'm going to start with, the hearing officer's authority and then the timing issue. And I'll discuss why both of those points lack merit. If the board members are comfortable with the facts, I'll just dive right into that legal discussion. So I'm starting with this hearing officer's authority. The hearing officer incorrectly concluded that she lacked authority to deny an OSS application for noncompliance with the critical areas ordinance. So there's two sources of authority that show that her conclusion was wrong. There's state law, and then there's sanitary code language. So I'm going to start with the the state law. The state law enabling the hearing officer system, as well as the local board of health system, is very clear that she has authority to deny based on provisions applicable to OSS systems. The specific state law is RCW 70.05074, and I'll just read it because it's quick. If the local health officer denies an application to install an on-site sewage system, the denial must be for cause and based upon public health and environmental protection concerns, including concerns regarding the ability to operate and maintain the system, or conflicts with other existing laws, regulations, or ordinances. So there's a couple takeaways from this provision. First takeaway, the biggest one, is that it uses the phrase other existing laws, doesn't limit itself. So it says she has cause to deny, and I'm sorry, I'm referring to Examiner Rice, has cause to deny a sanitary application for non-compliance with other applicable laws. There's no restriction. Critical areas ordinance is wrapped into that. And that code doesn't mention the sanitary code as the exclusive authority. And it's interesting and poignant in this case because the code explicitly says environmental protection as grounds for denial. And this is particularly on point given the codes that were bypassed by Thurston Health not routing the application to the planning department were the critical areas ordinance and the shoreline master program. And these are both laws which are intended exclusively to protect the environment. So state law gives the officer authority to reject an OSS application that conflicts with applicable laws like the critical areas ordinance or the SMP. So that's the state law. Now moving downwards to the sanitary code. The sanitary code is also clear that the hearing officer has authority to deny an application for non-compliance with the CAO or SMP. And this is from Article 4, Section 25.5. And this is the version, I just want to be clear that this is the version of the code that to which this application is vested. Thurston Health recently updated, I believe it's April 2025. So this is that previous version. And I'm going to read that section verbatim again, just because it is clear. The health officer shall have cause to deny an OSSA or OSSP or an operational certificate, or to revoke, suspend, or modify a required OSSP or operational certificate of any person who has, and then we jump down to 25.5.1, failed or refused to comply with the provisions of this article or any other statutory provision or rule regulating the operation of an OSS. So the takeaways from this provision, like the state law, it uses extremely broad language. The officer can deny an application that fails to comply with any statutory provision regulating the operation of an OSS. And for the lawyers, that disjunctive, that use of or is crystal clear. It's the sanitary code or other provisions. So we have the state law and we have the sanitary code, both which give the hearing officer an authority that she claims she did not have in her decision. So she had a tool in her tool belt that she didn't realize she had. And I apologize if I use examiner, it's because I'm in front of Examiner Rice as well multiple times. I intend to say officer. So that's the hearing officer's authority piece. Is she does have that authority from state law and from sanitary code. And so that's the first bucket. And moving on to the second bucket, which is the timing issue. Land use review must happen before an installation permit is granted. And we don't have to speculate on that this is the case. The code actually gives us an answer on this timing issue. The critical areas ordinance says the county, I'm going to pause there, the county shall not authorize impacts to critical areas or buffers unless the applicant demonstrates an inability to avoid impacts and that there will be no net loss of critical area functions. That wraps up critical area review, mitigating for no net loss and an inability to avoid impacts. And that is Thurston County Code 2401-035A. That's from the general requirements of the critical areas ordinance. So no authorization, the county cannot authorize impacts until this review occurs. The county is a defined term. The code defines county broadly as County of Thurston, State of Washington, unless otherwise specified. So the takeaways from this provision are that the county as a whole, including its departments, cannot issue installation or operation permits, so that involves impacts, until after critical area review has occurred. And the whole point of critical area review is to assess impacts before they happen so they can be mitigated. And so without this requirement, critical area review is rendered basically meaningless. And the sanitary code itself reinforces this timing issue. The sanitary code is clear that an OSSP, an on-site sewage permit, is the last step in the development process. It's not a preemptive step. It's not a development step or intermediate step that can happen commensurate with other action or other review. It's the last step. The sanitary code defines an OSSP as a permit issued by the health officer. This permit grants authority to the permit holder to install an OSS in accordance with the approved design. So it's a grant of authority to actually install the system. And that's from Article 4, Section 3 definitions. Excuse me. I'm getting over food poisoning, so I apologize. The takeaways from this provision, an OSSP approves installation. It approves moving the earth. It approves putting in the system. It's not the same as critical area review or SMP review, which is about the appropriate use of land, whether this is feasible, reasonable, given the attenuating or attending circumstances. So that's the code argument there for the timing issue. There's also simply a practical consideration here. Requiring land use review before issuing installation permits to put in structures makes practical sense, and it's the only tenable interpretation of the codes we reference in briefing. So land use codes, again, and I've already touched on this, they ask whether a proposed use is appropriate given the location and circumstances. The critical areas ordinance at its most basic level asks whether a use is appropriate on a site given the surrounding environmental characteristics. And we cite a lot of examples in our brief that discuss about a siting. Critical area asks questions about siting. You got to consult with the Department of Fish and Wildlife to ensure a site is proper. You have to make sure no other sites are available if you're going to place.
5 minutes left.
You have to make sure there's no other site available if you're opting to site within a critical area. So that's the siting issue. In contrast, installation and operating permits like OSSPs are issued after it's been determined that a proposal is appropriate. And I'm going to call this an order of operations where we go to land use and then installation. Thurston Health, it acknowledges that it adheres to this order of operations. So it concedes that the undisputed testimony arguments and briefing are that Thurston Health routes applications for new or expansion systems to planning. It doesn't route already issued permits. It routes applications. So those applications can be reviewed by the appropriate department. And this matters because there's this suggestion that when multiple departments are involved, it's kind of this hodgepodge, everyone can review at the same time. That might be true to a degree, but not when it comes to moving earth and putting a system in the ground. That's the last step. Just like if you're building a building, occupancy, construction permits are the last step. And I'll go ahead and stop there and save the rest of my time for rebuttal. Thank you very much.
Real questions to you? Or you want to wait?
You could, if it's more appropriate to ask now, I think that's reasonable.
Yeah, I'd like to ask you a couple of questions.
Please.
So if the hearing examiner, and I call it examiner, officer, if the hearing examiner was correct about the authority, would your clients have an alternative pathway for appealing what occurred here in your estimation or to your knowledge?
I'll restate just to make sure I understand.
Yeah.
So the question is, if the examiner is correct that she doesn't have authority to ensure compliance with the critical areas ordinance, do we have recourse for this installation of a septic system? Is that your question?
Would you have recourse for, if there was assuming hearing examiner is right about that, and assuming that you're right about some kind of failure of critical areas ordinance review or shoreline master plan review, what would be the recourse? What would be the procedural recourse for your clients?
The procedural recourse is here in front of you. You are the board that issues these permits and ensures that they follow the applicable laws. So this is the forum to challenge that this septic was approved, the permit was issued in non-compliance with all the applicable regulations. So this would be the forum to do that.
And if the hearing examiner is right that it's not, then there would be no other place to go.
So if the hearing examiner was correct, the only other thing I can imagine is there'd be we could seek code enforcement action. So go to the planning department and say, hey, there's been a violation of code because the system was installed without a permit. And so we request some sort of code enforcement remedy. Yeah.
Second question I have for you is I don't know if you addressed this in your appeal. It was in the underlying hearing examiner's decision. The issue, I'm just wondering, my question is going to be, does this issue matter from your perspective? The issue was raised that it's okay, you could authorize an oversized system, but there are limits on vegetation. Like you can't clear any more vegetation that's absolutely required.
Yeah.
So by allowing an oversized system, you're necessarily violating that other separate limitation. Does that argument have any play at this juncture?
So I thank you so much for bringing this up. There's an undercurrent in this case about a policy decision from Thurston Health, and it comes out in their most recent briefing. It's sort of a dog whistle, and I'll just try and make it explicit that replacement systems are better than what was there. They're better than what was an older system, better than outdated modalities, better than a failing system. So there's an assumption underlying this policy that if we put in this system, it's already more protective of the environment.
1 minute.
And here's the problem with that issue.
You don't get, I think you can.
Yeah, I've been keeping track. We have
You have three,
4 extra minutes for
you
you.
have 3 minutes and 30 seconds for a rebuttal. The question and answer is not
count against your judge. So the policy is that it's more protective. We've identified a flaw in that assumption with this case. The critical areas ordinance says you can't clear more than is necessary. An arbitrary distinction of oversizing a system because you want to enables that applicant to clear more vegetation than the critical areas ordinance will allow. I'm an environmental lawyer. This is an environmental case. This is a authorization of oversizing systems, and it is arbitrary. We asked this in hearing. What would stop an applicant from oversizing with 100 Glendon tank? And there was no adequate response. Or 100 tank system. What's to stop them from a 6-bedroom system as opposed to 4? So then they're clearing enough vegetation, clearing more critical areas, more shoreline conservancy than what's necessary to meet the approved septic, which is a 2-bedroom. So the merits, I'll keep these two things separate. The policy of, the technology's gotten better. Maybe we shouldn't have to send these repairs to the planning department. There may be merits to that to some degree, but it's got a big flaw, and it was identified in this case. And that policy is entirely separate from what the code requires. The code requires that our appeal is granted. Their policy belongs in the legislative process or the rulemaking process. I don't know how that works. They need to be going the appropriate channels to say, we'd like a rule change. We think this is based on outdated technology. So to your question of why this matters, in testimony, Jim Hunter, who installs a majority of the septic systems in Thurston County, he said that I have never done critical area. I've installed hundreds of systems without critical area review. In my mind, this is a death by 1,000 cuts of Thurston County's remaining critical areas, because I can't imagine how many of those systems were oversized. And the interest in oversizing system, it's not hard to understand. The applicant might say, you know what, I want to add a couple bedrooms eventually, so let's go ahead and oversize today. And the installer gets the benefit of a bigger system. And so what happens is we have countless oversized systems out there where more vegetation has been cleared than what was appropriate, and more vegetation in critical areas of Thurston County.
Sorry, you mentioned conservancy, and that reminded me of one more question. On the top of page 13 of your memorandum, you say that the conservancy is that you say this means Mr. Anderson has installed an on-site septic within conservancy environment despite that it is prohibited in that area.
That's correct. So the only things that are allowed in the shoreline conservancy environment, and this would come out in planning department, are transmittal pipes and distribution pipes. This has septic tanks, and I can't remember the infrastructure, but this has more than distribution and transmittal lines within the shoreline conservancy. So that'd be another thing that would be raised by planning review. They'd say, well, you're in the most protected shoreline environmental designation that we allow under the master program. And with that in mind, we don't allow very much septic infrastructure there. So the only thing you can put in there is these low impact distribution and transmittal lines. Your septic tanks have to go outside the shoreline conservancy. And that would come out in planning department review.
They have to look at what's potential.
Ray, your audio is breaking up.
I apologize. I went off mute there for a minute.
Oh, no problem. Just making sure we didn't miss a comment. Thank you.
All right. Any other questions before we move on? All right, thank you so much. We'll give you your extra 3:30 on the other side. All right, the department now has 15 minutes to present.
Thank you. My name is Seth Dickey. I'm a deputy prosecuting attorney for Thurston County here on behalf of Environmental Health. And I want to, start by addressing a few things that counsel for the applicant raised in his argument. First being the authority of the hearing examiner. Counsel cited first state law RCW 70.05.074. And I want to be clear about the reading of this statute. which is that it gives it creates a requirement for when a denial is issued. It says if the health officer denies an application to install an on-site system, and so again, this is also dealing with installation, right, as opposed to repair. The denial must be for cause based on public health, environmental protection concerns, including concerns regarding ability to operate, maintain, or conflicts with other existing laws, regulations, or ordinances. So this is a requirement for when a denial is issued. It is not a requirement that the hearing officer explicitly review and confirm other sources of law that are not in front of them, such as the Critical Areas Ordinance or the Shoreline Master Program, when, as in this case, it is really the sanitary code that is the controlling law here. So I think it's important that we look at the words of that statute very, very carefully here. Another, I think, important clarification is that environmental health is not the entity, and public health is not the entity that routes these applications between the relevant departments. That is done by CPED staff. So CPED routes this to environmental health, and if CPED determines that it's appropriate for SMP or CAO review, it routes it to its own entities for conducting that review. That was made clear in the testimony, and it's not, although the applicant's attorney suggests that it's undisputed and conceded, that is just not the case. So let's see here. There are a few other points I want to make clear that were raised in the briefing by the applicant. First is that standing is an appropriate issue for this board to consider on appeal. It is an issue that is called out directly in the appeal packet that the applicant addressed in its application, in its appeal. In addition, standing is a component of jurisdiction, which can be raised at any time. I think there's, significant case law on that, and the rules of appellate procedure 2.5a indicate that jurisdiction is an issue that can be raised on appeal at any time. And, again, I think this is not the focus of this matter here, but the applicant indicates that basically risk of harm should be conflated with injury in fact. And as I briefed, the department's position is that that is, not a one-for-one comparison. So another thing I think it's important to point out, and again, this is a little bit in the weeds here, but in the sizing of the water source, the Group B versus Group A water source issue, the briefing for the applicant switches wax and initially cites to the correct Group B WAC, but then switches to the Group A definitions. So let me just give me a moment to find that here. Let's see. Yeah, so the applicant indicates correctly at first that WAC 246-291 applies, which is the Group B WAC, but then indicates that there are no applicable definitions for residential, non-residential, and service connection, but then cites to 246-290, when in fact, the Group B definition system does have those definitions. Service connection in WAC 246-291-01061 is defined as a residential, non-residential, or recreational service connection. And I briefed that in the department's responsive memorandum, so I won't restate the brief here, but I think it's important to recognize that there's a little bit of a switch in the applicant's briefing. Let's see. So I think, the primary issue here is whether the hearing examiner appropriately determined that environmental health does not need to wait for CPED to issue a critical areas ordinance or SMP review before granting its permit here. And I think it's also important to note that should the applicant actually have a complaint that there was a violation of the SMP or the CAO, the appropriate remedy would be to file a complaint with CPED. So CPED could then do that investigation and make that determination. I think it's critical to note here that although the applicant suggests that there are violations of the SMP and the CAO, CPED is the entity that would have the authority to make that determination. And to my knowledge, there is no such determination in this case. So the argument that the hearing examiner was without authority to grant the permit based on a presumption that there was a SMP or CAO violation is kind of a false premise. There has not been a determination to that effect. So if the applicant believes that there is a violation, they can make a complaint to CPED. CPED can investigate and presumably issue enforcement or some kind of remedy. This board, the department submits, does not have effectively the jurisdiction to order CPED, in a separate department, that it must conduct a review or that it has to do this kind of analysis when there is a repair versus an installation. So let's see. I think I'd welcome any questions, and otherwise rely on the briefing.
Any questions?
Yes.
Could you help point me to where in the record, I'm trying to understand what the criteria was for repair versus an expansion / installation. Could you just help me understand that a little bit?
Sure. Give me one moment.
Thank you.
Yeah, so Article 4, Section 3 indicates that an expansion effectively involves an increase in flow, the flow generated by the residents. And that will be indicated by an increase in the number of bedrooms, right, that the septic system services. And I think it's important to note that the applicant conflates flow with capacity, right? So the sanitary code requires that there be increased flow, and it is not relevant to the definition if the capacity of the system increases, but the flow remains the same, right? So that is the specific definition there, if that answers your question.
Thank you.
Yeah. Any other questions? Yeah.
So
answer.
does the critical areas ordinance and shoreline master plan apply to a septic repair?
So I'd submit that it is not environmental health's duty to review the SMP and the CAO for a repair, right? I think it's outside the sort of purview of this permit process and appeal. I'd submit that that question really would be answered by the Department of Ecology, which is the regulatory authority for the Shoreline Master Program.
It's so you don't think that we as a county have that obligation under the statutes? We'd have to ask ecology.
Well, I think it would be, I'm not sure what the remedy would be for this board, right? If this board determines that really CPED should have done a review of the SMP and the CAO. I don't think that this board can effectively order CPED to do that, right? So I think that there would be, other issues with effectively delaying the permit indefinitely if CPED refuses to do that review. So I'd hesitate to suggest that either. So I'm not sure what the remedy would be here, if that makes sense.
And on standing, I mean, neighbors, the next door neighbor is like, that's every land use appeal, like.
Sure.
what- And the Supreme Court said neighbor, it's pretty much, it's cited in the briefing. What is your standing argument exactly?
Sure. So the case law, Supreme Court has stated that there is a very low bar for standing to neighbors in permit applications like this. So neighbors, I think, have a presumption of standing. However, there needs to be some injury in fact, right? There needs to be some harm that is realized. And in this case, my understanding of the applicant's stated harm is that if the system fails, then in that hypothetical, it's, there is a risk of damage to their property, the shoreline, the blackberry bushes, et cetera. But I think the case law is pretty clear that purely hypothetical harm is not injury in fact. So, I recognize there is a presumption here of standing, but I think it is a fair issue to raise.
Didn't the hearing examiner herself at the end of her opinion, sort of talk about how close these folks are and there was concerns are valid and understandable. Earnest desire to protect enjoyment of their property. I don't know, it sounded like the tone of the finding from the conclusion of law from the hearing examiner seemed to almost support the statement.
Yeah, it was not argued, I think, proactively below. And I wouldn't identify that as a fault of the hearing examiner in not really,
digging into it.
holding, the applicants, to sort of strict scrutiny on that issue. Mhm. Any other questions? Okay, thank you very much.
You like your 3 minutes, 30 seconds?
Yes. Thank you, board members. Council stated that we are asking the board to order CPED to do something. That's absolutely not true. We don't ask the board to order CPED to do anything. We ask the board to reverse the approval so the examiner, can not approve the application until the applicant has undergone the necessary review by the planning department. So that's what we order the board to do. Has nothing to do with order C. You don't have to communicate anything to the planning department. Council stated that we have not asserted that a violation of the CAO has in fact occurred. The CAO violation is that review hasn't occurred and it applies. The applicability code of the critical areas ordinance is crystal clear that it applies to critical areas where they exist. The review hasn't occurred. There's been no CAO review. There's been no permit issue, and that review culminates in a permit. There's been no report. That's the violation. There was a question from the board. Does the CAO SMP apply to septic? Absolutely. We cite provisions in our brief that the language is all about on-site sewage systems. So there are countless provisions, not countless, there are several provisions in the CAO and SMP that apply to septic systems. And I hesitate to even talk about the standing argument because And we have a closed record here. I can't introduce any facts. On the record, those the Glendon systems are large structures. They're put in the ground. Presumably, those a lot of dirt had to be removed. I'm going to talk about the construction of this septic system because we talk about the failure in our standing argument, and we don't talk about what happens during construction of these septic systems. So I'll represent to you that if there'd been an opportunity for a factual hearing and that this had been brought up at the appropriate time below, we would have discussed construction. And you can imagine, based on the facts in the record, about the location of these septic systems, the amount of earth that had to be moved, the down gradient towards Henderson Inlet, and the fact the McCulloughs, they practice aquaculture immediately in Henderson Inlet. So directly down gradient from where these septics are installed are shellfish. So these are the kind of arguments and facts that would have been developed more robustly had standing been raised. And it's absolutely a jurisdictional issue, but it also requires a factual determination. And having it on a closed record is unfair. So that's all I'll say about standing. Any final questions I can respond to from the board? Thank you very much for your time.
Do you need any rebuttal? All right, so last final call for any questions either on Zoom or in the room. All right. So this concludes the hearing. Thank you so much for coming before us.
Thank you.
Thank you. So the board will issue its written decision on or before September 24th, 2025. Yeah, is that correct? That's 15 days. Is that right?
Yeah.
Thanks. All right, so now we will go into executive session again to discuss the arguments heard, and it is 5:15, so I'm thinking 5:30 will come out. That sounds good.
Are we,
So we're now coming out of executive session back into our regular Board of Health meeting. No new items were submitted in advance of the meeting, so we aren't going to add anything there. So the next order of business is adjournment. We have a motion to adjourn the September 9th, 2025 Board of Health meeting. Heidi moves. Any seconds?
Second.
And Commissioner Class seconds. All right, all in favor of adjourning our meeting?
Aye.
Hi.
All right, no opposed. Good to go. We are adjourned at 5:47 PM.
good job, Chair. Time to find it. Oh, thank you.